Hello, everyone. This is the Joseph P. Dwyer Veteran Peer Support Project. And this video is going to be specifically about tenant rights, especially those in Jefferson County. I recently went to a tenants right class brought on by the Assistant Attorney General Office in Jefferson County. A legal disclaimer, this is not in any way legal advice. This is just me saying my thoughts and what I've learned from this tenants right class. Please make sure to go to your local Attorney General office, either by phone or website. I believe for the state of New York it is ag.ny.gov. I'll leave that in the link below, so you guys could go to that to refer to any other news, any other forms or articles, or resources that they may have. Also, the Attorney General's office is what people call the lawyer of the people. If you have any legal complaints or need to file anything against, say, a landlord or a business, for whatever reason, you can go to them and ask if they do that specific type of thing. But yeah, when you're getting ready to rent, understand that the lease cannot make you break any laws, like in the actual form itself. Like, it may say, like, if you're not paying rent, you have to jump off your back balcony if you're on the second floor or something like that. That is not legal in any means, or that you have to, like, be a part of any illegal organizations that may be there. Also, the tenant cannot, or the person applying cannot be denied based on the fact that they were evicted from previous properties. But they can use a number of factors, such as your credit report, criminal background check, or other factors, including the evictions. But it cannot just solely be on that, or you cannot be denied because you're getting Section 8 housing or anything under ADA, such as discrimination against disability, veteran status, sexual orientation, religion, or any of those factors are protected by U.S. law. But again, please check with local laws, as well as the Assistant Attorney General Office, to figure out the stipulations and legal reasons. When it comes to the security deposit, you must be given a receipt. It's the a receipt of how much it is, and what date you gave it, so that way you have legal records of it. If you are having to do a background check for your property, it cannot be more than $20. Like, that is the sole amount you pay. It doesn't matter where they get it from. They have to go with a cheaper source if it's over $20, and they're saying it costs more than $20. If they don't, and they deny you it, Attorney General's office. Tell them about it. They'll help you file a complaint or tell you what the stipulations are. And with any background check, you must be given the result of that background check as well, and a receipt for to the deposit and everything like that. You can do your first month's rent and your deposit. There's no first, last, and security deposit. A renter cannot actually demand all three of those all at once. Obviously, you're gonna have to do your deposit, you're gonna have to do your application fee and stuff like that, which is all legal. But having first and last rent, that is illegal as of, I believe, 2019. Again, please check your local laws and your AG's office to figure out if that's still a thing in your local area. There cannot be lease provisions, basically meaning things that are put into your lease that's waiver a lot of your rights, such as like accepting the landlord from any harm done, like the roof comes down because they didn't properly maintain it and you get hurt because of it. Even if it is in the lease, that is still illegal, and that is honestly a red flag for me. If I was to see that, consult your AG's office, make sure that they know that that's actually in there. That might have honestly been a mistake or something, but definitely investigate that. Your landlord cannot have your furniture as security for you paying rent, basically meaning if you don't pay rent for a month, they can take your furniture. That is illegal in many ways. And usually when you vacate the premises, the landlord must try to mitigate as much cost as possible for when you're leaving, so that way it doesn't completely screw you over, for lack of better terms. They have to legally mitigate as much as possible, try and cut down the cost for you to get you a break. Um, you can't waiver that right. You cannot waiver the warranty of habitability, which is basically meaning that you aren't in, like, let's say, like, an apartment that doesn't have heat, that doesn't have water, that doesn't have proper security. That all is still illegal. You are still protected underneath that, even if it is in the lease. But again, like, question it, ask about it. If they say, yeah, that's a thing that you have to sign and that's going into effect, contact your local AG office. And another thing is the restriction of living with immediate family or other occupants. Basically meaning you cannot live, say, with your spouse or your kids. They're saying no, they cannot be there. That is illegal as well. Obviously, if you're in a certain type of program, such as like a halfway home, or like, for our organization, we have apartments for veterans to stay in up to 6 months, but they have to be living by themselves. Unless, like, they tell us beforehand, hey, me and my wife or me and my kid are homeless, we kind of need a place to stay. We'll work that out, but obviously that is different than renting, because you're paying for it, and that's a different program in itself. Transitioning to while you are renting, in case of, like, and I'm going to go around a little bit here with different things. In case of you end up in the eviction process, say, like, you haven't paid rent for 2 months because for whatever reason, and then they start sending you letters basically saying, like, oh, we're starting the process to evict. If you pay up your rent and all the way, like, back rent as well, the eviction notice has to stop. The whole process has to stop. And if that was to happen again, they would basically have to start all over again. Obviously, that could possibly affect you being able to stay there after your lease is up, but that's a whole different story in itself. Security must be maintained by the actual landlord or the landlord company, like, for safety of the tenants, such as door locks, window locks, make sure there are doors there, and in, like, special cases such as domestic violence issues, they have to change the locks, like, God forbid something happens. All rental properties must follow ADA rules, such as, like, say, having disabled person parking, like, the blue placards and stuff like that, being able to have those in front of your apartment complex if you have one of those. Possibly, and other things. Repairs, when you put in a work order, must be done in a timely manner. Depending on certain things, they might need to do them in 24 hours, such as our, like, fridge. The refrigerator must be done within 24 hours, but please check your local laws for that. Again, when with the warranty of habitability, it must be livable, meaning, like, no bed bugs when you move in, no roaches or flies, or just a mess of a place. Obviously, like, if you live that way, that's a different story in itself, but when you move into the apartment and you are there, it must be habitable. When it comes up to your lease and whether or not you're able to renew the lease, that is up, up to the landlord. Typically speaking, they must give you a reason. Please check your local AG office and your local laws to verify that. I know I've been saying this a lot, but again, this is not legal advice. This is what I personally learned from being at the, this tenants right class. But depending on how long you have been there, you are given certain, I guess you could say, time to find a new place. If you've been there for less than a year, 30 days notice, in writing, via mail or, in person. I believe it's usually certified mail, so that way make sure it gets to you. If you live there between, been there over a year but not so much 2 years yet, you must be given 60 days notice. And if you've been there for 2 years or more, a 90-day notice, so that we can figure out, whether you're going to fight it, or if you're able to fight it, or if you're going to have to find somewhere else to live. And usually they do give a reason, depending on the situations, they might not. But again, if your place is perfectly fine, they must give you back the security deposit. But that is something else that you're going to have to work out with your landlord. If the building is sold while you are renting, though, all security deposits must be transferred to, and like this is on the actual landlords themselves. The old landlord must transfer your security deposit to the new landlord, meaning that they can't charge you again. And that is actually whether or not the old landlord actually pays them that. And say you move out 2 months after the new landlord takes over, they must give you your security deposit back if everything is spick and spanny. Also, all tenants must be notified via mail, certified mail, I believe, or certified or registered mail on the building being sold, who the new landlord is, and all the relevant information for that. One thing I do want to say is if there is a domestic violence issue, please contact your Attorney General office to see how and what laws do protect you and what can help you in that type of situation. Again, this is the Joseph P. Dwyer Veteran Peer Support Center. My name is Jesse Corrales Estrada. I am a peer advocate here in the Jefferson County. If you have any questions or anything, please leave it in the comments below. Like, share, please try and get this out to not only veterans but other individuals, so that way they know what types of rights they have, and resources that they can go to, because I'm a renter myself right now. I completely understand not knowing everything about it. I hope you guys like this video. Subscribe. We're going to be coming out with a lot more here soon. Thank you.